The Department of State Services has reportedly abandoned the case involving 5 activists arrested on July 4, 2021 at Dunamis International Gospel Centre, the Glory Dome, Abuja, for wearing T-shirts with the inscription #Buhari must go. It will be recalled that the activists, namely Ben Mannaseh, Emmanuel Larry, Victor Udoka Anene, a blind saxophonist, Samuel Gabriel and Henry Nwodo, were detained for 30 days by the DSS and reportedly denied access to their families and lawyers. They were finally released from DSS custody on August 3rd. Justice Anwuli Chikere of the Federal High Court had on July 26th, while ruling on the ex parte motion filed by the activists, ordered the DSS to immediately release them from detention, but the order was disobeyed by the DSS as they hurriedly filed a trumped-up charge at the magistrate court. The activists were then rearraigned on July 28th before a magistrate court sitting in Pape, Abuja, on 5 counts, including the charge of conspiracy to disturb public peace, an offense it said was contrary to Section 96 of the Penal Code law. The defendants pleaded not guilty to all counts. The Chief Magistrate, Mohammed Zubairu, after he had listened to the defense and prosecution counsels, admitted the activists to bail in the sum of 500,000 naira each, and with one shorty in like sum, who must submit his or her national identity card to the court. The shorties must be residents within the jurisdiction of the court. Surprisingly, at the resumed hearing of the case on Monday at the Wuse Magistrate Court, following the transfer of the case from Pape Magistrate Court to Wuse 2, the DSS lawyer, I. Onutu, representing the prosecution, was absent in court. The lawyer to the activists, Barrister Tope Temokun, thereafter asked the court to strike out the case for lack of diligent prosecution.
We both took today's date. When we got to that place, ordinarily the court will see by 9. So even as at that 9 o'clock, they were now in that court. We expected them to be there so that we'll be informed together that there has been a transfer of the magistrate. But we had to leave that place to rush down to Uze Zone 2 because they said the file is going to be taken here. On getting to this place, to when the matter was called, it was called as number 1 on the list. The prosecution, that is the lawyer to the DSS, they were not here too. So we applied that the matter be struck out, the charge be struck out, based on the fact that when you bring somebody to court, it's not something that is very convenient. But you have a case against that person, if the person should now voluntarily be in court and you are absent, just like I said to the court, the application was premised on the fact that we were not aware that the matter would be taken here, but we are still here. Why? Because we were diligent enough to be before the magistrate court, the Pape. We were diligent to be there. So if the defense, the prosecution too has been diligent to be there, that means we'll be here together. It's not a matter of whether you don't have notice. We didn't have notice too. So, but they are not here. So we applied that the charge be struck out, but the magistrate said because the matter is coming up for the first time before this court today here, that is going to give an adjournment at the instance of the complainant. We did apply for an adjournment because we are ready to go on with the matter.
The matter was adjourned to September 20th, 2021 for hearing.
Director General of DSS is also facing a criminal charge at the Federal High Court for contempt of court.
Yes.
So that he's also going to be prosecuted so there's a contempt charge against the DG of DSS. So there are 2 criminal aspects to it. The criminal trial here, which they are running away from, but the DG cannot run away from his own criminal trial at the Federal High Court when they resume.